Hi Victor, I want to ask you and all my viewers to watch a video by D.P.R. Jones about Peter Popoff, who was a scam artist and religious faith healer. Alright, I know, I'm being redundant when I call him a scam artist and a religious faith healer. But this needs emphasizing. He's also a fraud, a worm, a scumbag, and a sleazeball who tells his audience to get rid of their medicine because he can heal them with the help of the Lord! He can heal them! Now, it would be bad enough if he was just scamming the weak and gullible out of their money. But it's worse than that. Someone may die if they follow his advice and get rid of their medicine and put their faith in his quackery. It is important for as many people as possible to see this video. I'll post a link in the sidebar, so everybody should watch it now. Alright, I'm going to assume you've all watched it. Now, this video is like an inoculation. Anyone who sees it will be immunized from his fraud. So the more people who see this video, the less damage he can do. But I want you, Victor, and everyone else to watch it for another reason. You see, Victor, you and I disagree on whether we should have to ask for permission before using clips of other people's videos. I maintain that being able to make fair use of other people's works is absolutely essential for the well-being of society. I maintain that you shouldn't have to ask permission because there are a lot of weasels out there who need exposing, and to properly expose the weasel, you may have to quote him exactly. And, I maintain, no weasel is ever going to give you permission to use his material to expose him. You, on the other hand, seem to think that you should always ask permission before using someone else's video. At least, that is how I interpret your position. Perhaps it's a bit more nuanced than what I'm giving you credit for. And if I'm distorting your view, then please let me know and consider this an apology in advance. I'm asking you and all my viewers to watch the video on Peter Popoff because it is one of the best examples I've ever seen on the necessity for fair use. I don't think I will ever find a better video to demonstrate why you shouldn't have to ask permission to use someone else's video. Does anyone in their right mind think for 1 minute that Popoff would have granted permission to use his clips to show that he's a fraud? Of course not. Now, suppose Popoff were to claim that the video libeled him, and he tried to get a court to remove it because of its libel. Well, a court wouldn't automatically grant his wish just because he went, "Boo-hoo, he libeled me." A court would actually ask him to show some evidence that the statements made about him were false. A court would issue an injunction against the video only if it thought that he might have a case. In other words, the court system acts as a guardian against false claims of libel used to suppress free speech. But suppose instead he tried to get it removed under copyright infringement. Legally, he would have absolutely no justification to do so because it clearly falls under fair use. But suppose you said, "I have a justification for sending a DMCA." The first part of the four-part balancing test involves the purpose and character of the use. Well, the use is for libel and slander, and this is not something that is covered by fair use. Now, I've seen several people using this reasoning to justify DMCAs, and in fact, this was at least one of the bases, if not the main basis for Amendum's lawsuit. Maybe I shouldn't speak about Amendum now, because his account has been suspended, but he can still reply with his Do Not God channel. And indeed, he has posted a comment under that account yesterday challenging me to back up my oft-repeated claim that this was an improper use of copyright law. So I will go into it in a little more detail. And I stress the word little because to really do this topic justice would take a lot more time than I can devote now. And you're probably all going to be grateful that I'm not going to devote now because I'll bore you to death for an hour doing so. So this is the Reader's Digest version. And my argument will not just pertain to Amendum because I've seen several others use this argument as well. Logan Spearman 2, Irish 282, and Dynacats Loves Me. Are you listening? Okay, let's look at the first prong of the four-part fair use test in more detail. Section 107 of the copyright law says that the first factor to be weighed in deciding whether a use is fair use is the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. Nowhere in the law does it mention whether a work's defamatory nature should be used in evaluating whether or not it falls under fair use. However, the word including is used in this statement in such a way as to imply that there may be other considerations besides what is explicitly listed in determining fair use. And indeed, courts have determined that works of criticism and comment, parody and satire, scholarship and research, news reporting and teaching are likely to fall within fair use. The courts have also determined that the more transformative the work in question is, the more likely it is to fall within fair use. By that I mean that the more the work has been added to or changed, the more likely it is to be considered fair use. Theoretically, I guess a court could include whether or not a video was libelous as a criterion for determining whether the use fell within fair use. But I'm not aware of any court that's done so far, either for copying in the online world or the real world of books from newspapers. Now, I'm not a lawyer, so if there are any lawyers out there who can cite a case where a court has used defamation as a criterion for determining fair use, then please let me know. But if there is no such case, then that should tell us something. If there is no such case, then we must ask, why hasn't this been used as a successful defense before? There are several reasons to suspect why a court wouldn't buy the argument that you should consider the possible defamatory nature of a video as a criterion for determining fair use. First, if Congress had wanted copyright law to serve as a proxy for libel law, they could have explicitly stated in the law that whether or not a work was defamatory should be used in the fair use analysis. That is, of course, assuming that Congress has the authority to do so. I might note that copyright law is a federal law, and libel law is pretty much handled by the states. Each state has its own version of libel law, and as far as I know, there is no federal copyright law. Why is this so? I'm speculating here. It's strictly speculation, and I welcome input from anyone who knows more about this than I do. But I think it is because of historic reasons that Congress has not passed a national libel law. Article 1, Section 8 enumerates the powers that are to be given to the legislative branch. It explicitly gives Congress the right to enact copyright laws. However, it does not give Congress explicit permission to legislate libel laws. The fact that it does not give the power explicit permission to pass libel laws may be significant in light of the 10th Amendment, which states, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people." So at least at first glance, it would appear that the founders intended libel law to be the purview of the states and not of Congress. And if Congress were to use copyright law as a proxy for libel law, then it would be overstepping its authority. However, Section 1, Article 8 of the Constitution has often been interpreted broadly by the courts to give Congress more power than one might expect it to have, and I suppose a broad interpretation could be used to authorize Congress to enact national libel legislation. Now I'm going to post a link in the sidebar to an article about libel on the internet that appeared last summer in Wired magazine. There's one particular paragraph you should pay attention to. You'll note about halfway through the article it states that legal thinkers are considering the idea of passing DMCA-like legislation to handle libel. Under this legislation, victims of libelous statements would send DMCA-like notices to ISPs like YouTube, and then those sites would be obligated to remove the offending postings. Such legislation would be very dangerous because it would give liars and cheats and scoundrels a tool which they can use to suppress exposés about them. I bet Peter Popoff would just love to see such legislation passed. But the thing that is significant is that legal scholars are thinking about whether it would be a good idea to pass such legislation. If defamation was a legitimate consideration for deciding whether to use the DMCA to suppress videos on the internet, then why would they be considering the need for a new law? If anyone could legitimately use the DMCA to suppress libelous postings, then why not use a law that is already on the books to fight libel? The fact that some legal scholars believe we need a DMCA-like law to fight libel is just one more reason to believe that using copyright law to fight libel law is an improper use of the law. What would happen, though, if such a libel law was passed? Well, in addition to defamatory speech being removed from the internet, you can bet that a lot of legitimate and truthful speech would be removed as well. This would run counter to the law that was developed in a large number of cases. Wise lawmakers and judges throughout the years have recognized that you inevitably had to put up with some defamatory speech if you want to foster an environment where truthful and legitimate speech can flourish. If all defamatory speech was banished, then much speech necessary for a thriving democracy and for the general welfare of its citizens would perish as well. For example, New York Times versus Sullivan is considered to be the most important case in libel law. Just about every other Supreme Court case dealing with libel law flows from this seminal case. And in this case, the court stated, and I'm quoting, "Erroneous statement is inevitable in free debate, and that it must be protected if the freedoms of expression are to have the breathing space that they need to survive." Now, New York Times versus Sullivan was dealing with the press and public officials. This doctrine was later extended to include public figures as well. And so some may argue that this doesn't apply to private figures posting videos on YouTube. I would argue that the internet has blurred the line as to who is a member of the press and who is a public figure. This gets very complicated, and it would be very easy for me to take an hour to discuss this point in more detail. Suffice it to say that I believe this principle applies to postings on YouTube and to other internet sites as well. We have to put up with some defamatory speech in order to establish a space where legitimate speech can occur. I'd also like to quote a passage from James Madison that was cited in Neer versus Minnesota. This was the case where the Supreme Court ruled that it would be unconstitutional for the government to pass a law that puts a prior restraint on speech. This passage is written in very flowery language and is rather lengthy, so I'll only read part of it. You can read the entire passage, which I'll cite in the sidebar. Now, Madison stated, "In every state, probably in the Union, the press has exerted a freedom in canvassing the merits and measures of public men of every description which has not been confined to the strict limits of the common law. On this footing the freedom of the press has stood. On this footing it yet stands. Some degree of abuse is inseparable from the proper use of everything, and in no instance is this more true than in that of the press. It has accordingly been decided by the practice of the states that it is better to leave a few of its noxious branches to their luxuriant growth than, by pruning them away, to injure the vigor of those yielding the proper fruits." To sum up, giving copyright law the power to do what libel law was intended to do bypasses the protections built into libel law that safeguard the speech necessary for a democracy to thrive. If a court did decide that it was proper to use the DMCA to remove speech just because it was defamatory, then it would be giving the green light to everyone to abuse the DMCA to remove anything that they considered noxious, whether it was true or not. Oftentimes, a speaker may believe that what he's saying is truthful, and he may want to raise an issue that needs to be examined in greater depth. It may turn out that he was mistaken, though. It may turn out he was wrong. But do we really want to allow the DMCA to be used to remove such speech? As far as I'm concerned, the 9/11 truthers are a laughingstock. I'll post a couple of links in the sidebar. One is to a blog post by a former 9/11 truther who came to the realization that his movement was full of bullshit. The other is to a New York Times article in which 5 Guantanamo detainees confessed to being in on the planning of 9/11. So the question I want to leave you with is this. I didn't like the Bush administration, but painting them as being behind 9/11 was deeply libelous. But the Bush administration would never have been able to get the libel removed from the internet by using libel law because of the protections guaranteeing free speech that are built into the law. But should they have been able to use the DMCA to get rid of videos that claim that they were behind 9/11? I also want to point out one more thing. Take a look at the blog post by the ex-9/11 truther. He makes the accusation that the leaders of the 9/11 truther movement were just in it for the money. He claims that Alex Jones and the other leaders were intentionally lying, and they were just doing this to scam money off the memories of those who had perished in the tragedy. Does anyone believe that it would be proper for Alex Jones to use the DMCA to remove this blog post if he found it defamatory? Well, this has been the Mass Analyst, under and in.